Section 9, Provisional and Complete Specification. The Patents Act makes a distinction between a provisional and a complete specification, though both these specifications can be filed using the same form. So, the form that has to be used for filing a provisional or a complete specification is Form 2. Provisional is something that is being done as a temporary measure, and provisional also means that it will be followed up by a something which is complete. So, the provisional is something that is a time bound specification which has a short life, and by its nature the provisional has to be followed by something that is complete. Now, for those who have graduated will know that soon after graduation you get a provisional degree certificates, and the original or the degree certificate will follow through later. We do not call it the complete degree certificate. It is the understanding that provisional is meant for a short period till the original is issued. In patent law, a provisional specification does a similar function. The provisional specification can be filed, but you have to follow up with a complete specification within 1 year. So, that is the time period that has been given for you to file a complete. So, as soon as you file a provisional, you have to follow it up any time. It can be much before the 1 year period, but the maximum time period allowed for filing or following it up with a complete is 1 year. In case you do not follow a provisional with a complete, then the provisional will lapse. Now, section 9(1) tells that provisional following one complete, that has to be done within 12 months. 9(2) is a case of multiple provisionals being followed by one complete, that again has to be done within 12 months, but from the date of the earliest specification, earliest provisional specification. 9(3) allows the applicant to file a specification which looks like a complete, a purported complete. The Act uses the word purporting to be a complete specification. Once this is filed, I understand that you should be having this doubt as to what is the difference between a provisional and a complete. Now, to give you a very quick answer, the complete should have claims. Provisional need not have claims. It could also have claims, but if you file an application under Form 2 without drafting the claims, it will automatically be deemed as a provisional specification. If the claims are there, it could be considered as a provisional or a complete. It depends on how you prosecute it. 9(4) states that where a complete specification has been filed in pursuance of an application for a patent accompanied by a provisional specification or by provisional specification treated by virtue of a direction under subsection 3 as a provisional, that is the purported converted into a provisional, what we saw in the earlier subsection. The controller may, if the applicant so requests, at any time before grant of a patent, cancel the provisional specification and post date the application to the date of filing the complete specification.